prosecutor has told you that Yvonne Price hit her daughter, the 22-month-old Thiantha Price, in her stomach, hit her so hard that she died. And I am here to tell you that she did no such thing. Oh, she said she did. She told some police she did when she was under incredible pressure, and she recanted the moment that an assistant state's attorney by the name of Ben Cross came into the room. And you will hear the reasons why she said what she said, and why she felt at a certain point safe enough to say it never happened. But I want you to know, Yvonne never hit her daughter. Let me tell you what happened on the frosty November day before Thiantha died. It was early in the afternoon, and Yvonne had some errands to run. And so she hired Vanessa, who's a 13-year-old girl, the daughter of a friend of hers, to babysit Thiantha while she went to the grocery store, and she had to pick up some dry cleaning, and I can't remember what the third one was, but there were 3 things she had to do. So she went and she did those 3 things, and when she came home, she picked up her daughter from Vanessa, who was in the apartment building just south of where she lived, and brought her home. But what she didn't know, what Vanessa didn't tell her, because Vanessa felt bad about it and didn't want to tell her, and she didn't know, was that Thiantha had walked down the flight of stairs from, Vanessa lives in one of these, it used to be a single-family home, but it's been cut up into apartments. So there's like, the stairway goes inside, but there's apartments that have been just sort of cut out of the 3 floors, okay? And the it's just not in very good shape. You'll see some of the photographs, and the stairway's banisters are broken. So there's some places where there's banisters and some places where there aren't. And what Vanessa didn't tell Yvonne was that Thiantha fell down the stairs, hitting one of the stairs and falling off the landing down below. And Yvonne didn't know this. She wasn't bruised or anything that you could see. She seemed to be fine, and she just picked her up and brought her home. So that night, Michael and her dad and Yvonne and Thiantha, they have dinner. They're doing whatever they do, watch television in the evening, and Thiantha didn't really want her dinner too much. But those of us who have children and those of us who don't know, sometimes 2-year-olds just don't want to eat. You know, they just don't like it or whatever, and she didn't eat anything that night, and nobody thought too much about it. However, the next morning, when everybody was getting up, she seemed listless and feverish, and everybody goes, oh my goodness, Thiantha's sick. So Michael and Yvonne take her to go and get some help. And here, ladies and gentlemen, is where those of us who've been lucky enough to live in a little better world, to live someplace that isn't quite so poverty-stricken, this is where you are going to hear evidence that is, it's hard to even hear. Because this began the journey of a poor person to try to get help. First place they went was to a clinic. There's a neighborhood clinic on the west side there in Chicago where you can go in and you can see a doctor for a very limited amount of money. But when they got there, even early in the morning, the line was already quite long. When you're poor, you're in lines a lot. And when I say quite long, there were 30 or 40 people ahead. And Michael had to go to work later, and so they decided that they wouldn't stay at the clinic, that instead they would go to Bethany Hospital's emergency room. Okay? So they got on the bus. They don't have a car. They got on the bus, and they went to Bethany Hospital. And there they ran into a similar problem because Bethany Hospital was flooded with a bunch of people who had been injured in a major fire. Maybe some of you remember this fire that had happened in an apartment building on the west side of Chicago. And it was just totally crowded. It looked hopeless that they would get to see anyone. So Michael left to go to work, and Yvonne got on another bus and now went to Mount Sinai Hospital. And this is where the story gets even worse. The emergency room in Mount Sinai Hospital, I don't know how many of you are familiar with this term, and if I'm telling you something you don't know, you already know, but I apologize. But when you walk into the emergency room, there's linoleum, like foyer area, and there's a desk, one of those circular desks, with the information, where to check in and all that stuff. And if you're going to the emergency room, you check in there and fill out all these papers. When you're poor, you fill out a lot of papers. You got to show your green card, and you've got to show your Medicaid card, and you got to fill out 3 or 4 forms, and you do all that, and then you move into the foyer area, the waiting area, and they have there a triage nurse. Now, a triage nurse is supposed to take a look at all the people that are in the emergency room. You'll hear evidence about this, and decide who is in the most serious need, who's in the most dire situation, so that they, you don't want to be taking somebody who's got a paper cut ahead of somebody who's been shot, right? I mean, it just makes sense if you think about it. So they have a triage nurse at Mount Sinai Hospital. When they came into the emergency room, Theantha was still walking. Your mom was holding her hand, but she was kind of breathing funny, kind of a rattling sort of sound. And she was breathing shallowly and rapidly. But after she finished checking in, they went and they sat down. And ladies and gentlemen, we're fortunate because you're going to hear from a witness who happened to be in the waiting room. Just happened to be there because her uncle had an epileptic seizure in church, and she brought him there, and she was just waiting for him to be finished being treated, and she happened to be a trained observer. She, Miss Anderson, is a nurse. So she saw them come in and sit down, and Yvonne put Theantha on her lap, and they waited. The triage nurse was talking to a young man there's like a little conference room kind of off to the side, and she's talking to a young man and his mother. The young man was a teenager who had an extremely severe case of acne. And they sat there for somewhere between 45 and 50 minutes and didn't get called. And by then, Theantha was quite listless. I mean, was kind of lying on her mother's shoulder and not moving much. And so Yvonne got up, went back to the circular desk I talked to you about, and said, what's going on? And discovered that they had lost the papers that she had already filled out. So she filled them all out again and went and sat back down. And at this point, Miss Anderson walked over to Yvonne and her daughter. Ostensibly, she said to just say how the cute little girl she was, and she was. And she goes over there and she goes, oh my God, she's in cardiac arrest. All of a sudden, everyone's paying attention. They yank Theantha out of her mother's arms. They rush her back. They put her on a table, and they begin to do CPR on a 22-month-old baby with a full hand. You will hear evidence about that. You will hear actually a lot of medical testimony in this case. You will hear what it is that actually caused Theantha to die. It's a disease, it's called peritonitis. There's this thing that's in your stomach between your intestine and your stomach. It's kind of slimy looking, and it's called a duodenum, I think is how you say it. And if it tears, you literally poison yourself. That is, your waste materials get into your stomach and you poison yourself. And that's what caused Theantha to die. And you will hear from the emergency room surgeon, because she did have surgery, and you will hear that they will say, and their reports indicate, that Theantha died 15 minutes after surgery. But ladies and gentlemen, I will call, if the prosecution won't, I will call the anesthesiologist. And I want you to listen to what the anesthesiologist has to say about the fact that there was no heartbeat and no respiration 15 minutes before the end of the operation. The physician in the emergency room, when Thiantha died, looked at her and saw a little bit of blood from her anus. And so she said, "This is child abuse." Something killed Thiantha Price that morning. And the evidence will show that that something was indifference. That something, the evidence will show, was incompetence. That something, the evidence will show, will be the unmitigated, terrible crime that Thiantha Price and her mother have paid for being poor in this city. And ladies and gentlemen, when you have heard the whole story, when you have heard all the evidence, you will want to convict someone of Thiantha's death, but I promise you, it won't be Yvonne. The reason that I did an opening statement first is I wanted you to have the sense, the feeling of what it's like to hear about a case for the first time and how much power those first moments have. Okay? There's a second reason I did that particular opening, which I'll tell you about later. But it's really important to grab the jury and to have the jury with you at the end of opening statement. Now, I'm a law professor these days, which sort of surprises me. I kind of look around when they say Professor Lyon. I kind of, oh yeah, that's me. But and I teach students how to try cases, and I try cases, and then I talk in class and stuff like that. But I actually get a little bit more time these days, and I read studies. I shouldn't admit this in public, but I do. And most of the studies about how juries process information say that 80% of the decision is over at the end of opening statements. It's over. If you're not at least even at the end of opening statements, you got some serious, serious problems, okay? Winning would be better. Actually, personally, I'd like to stop at the end of opening statement and have them vote right then. Then I wouldn't be bothered with evidence, which I usually don't like anyway, okay? You want to take advantage of that moment, of the primacy, of the immediacy, of the things that you've been hearing about since you've been here at the college. Has it been 2 weeks now, does it feel like? And you want to always open. You always want to open. I hope there's nobody who's going to leave here who's going to reserve their opening or not give one. Because you give up that moment if you don't do it. But you have to say something, not just say something. How many of you heard the, ladies and gentlemen, I want you to keep an open mind, wait till you've heard all the evidence. Did you love that opening? That's stirring, boy. I mean, you know, that has you on the edge of your seat. You just, you know, I mean, that is filler. That's because you don't know what your theory of the case is. And I was a public defender for a long time, nearly 20 years. I understand what a big caseload is. I understand that you don't always have time to do huge, in-depth thinking about cases, but I want to tell you that 45 minutes spent brainstorming a case and working out a theory of the case will save you a lot of time and will allow you to develop an opening statement that has some power and means something to people. An opening statement serves many purposes. One of them is to establish rapport with the jury. This is especially important for those of you who practice in federal court and other jurisdictions where the judges are unenlightened and don't let you do your own voir dire or let you, you know, you can do anything you want in the next 2 minutes, counsel. Thank you very much, Your Honor. You're so generous, okay? And they have like a stopwatch, you know? I mean, how about approximating the 2 minutes, Judge? Wouldn't that be nice? But, you know, they don't do that, okay? You want to use that time to let the jury know where you, the human being, are coming from. But please remember this, if you don't remember anything else. You cannot sell what you wouldn't buy. You can't do it. It doesn't mean anything to you if you don't believe it. I promise you, nobody else will. There is something about an alchemy of a jury. They just know that. They know that much. Another purpose of an opening statement is to give the jury a way to hear your evidence. Now, sometimes I have cases where I don't have a case to put on. Perhaps some of you have that situation? Where you're sort of, cross-examination, credibility of witnesses, maybe lightning will strike the jury box, and I'm the only one with this theory. You come in the morning and there's certain files that are barking, they need to go out for a walk. Right, okay, everybody understands what I'm talking about, right? So if you have a case where cross-examination is going to be the bulk of what you're doing, you need to say to the jury that cross-examination is your evidence. Otherwise, they think you didn't put any on. I don't know what they think you were doing while you stood up for hours on end beating the hell out of the police officers, which is one of my favorite things to do. I know it's not polite, but I like boxing too, except, well, I'm not so sure these days. But anyway, you need to say to the jury that this is evidence that I will bring out, evidence that you would not hear if I did not ask these questions, okay? For example, if you have a snitch or a flipper or whatever it is you call people who turn on people. Those of you who are federal defenders, isn't the U.S. Attorney's Office, at least in Chicago, we call the U.S. Attorney's Office snitches are us? Yeah, okay. Then you need to explain that you will be cross-examining and that they will learn things about this person and about their motivations, and that this is your evidence, things the prosecutor is afraid to bring in front of them. It's always fun to say that sort of stuff because no matter what they front, it's never enough, is it? I mean, even if they front the fact that he's got, 12 convictions, I want to talk about that a little more, right? Okay? And it's also important if what you're doing in your case is attacking the sufficiency of the evidence rather than presenting an affirmative defense, okay? It's an identification case, and you're saying that the identification isn't reliable. Perhaps some of you have had this problem. You have a client who has a pretty good story. He says he was someplace else, and he says so for many days in the tender loving care of Area 4 violent crimes, okay? In fact, he says so in a court-reported statement. And so all they have, well, they originally had 4 eyewitnesses, but a couple of them, one got arrested for murder, another one got murdered, so then we only ended up with 2, and they had a little problem with the ID case because one of the kids let me interview him. I don't know why, he just did, perhaps maybe because I speak Spanish, I don't know. But anyway, he let me interview him, and he told me that that all 4 of the witnesses were sitting in the back seat of the police car, passing around photographs, and discussing the case in front of each other, and that they had 12 pictures, 6 of which were of my client. So, I've got a great motion to suppress identification, and I don't know about in your jurisdiction, but in both of mine, all motions to suppress will be, because the number 1 rule of evidence, does the prosecution need it? It's coming in, right? Okay. That's a universal rule, isn't it? Yeah, I thought so. So you know that you have a very good way of attacking how the identification went. It happened late at night. The opportunity to see was poor. And your client was somewhere else. But, see, I just felt I didn't want to put on these alibi witnesses. He was playing cards with his friend, Wacko. Okay? And just in case Wacko forgot his name, he had it tattooed on his goddamn knuckles. Okay? I didn't want to put Wacko on the stand. I don't want to put on that affirmative defense. I mean, sometimes these alibis, why is everyone always watching Kojak? I just don't want to do it. And I want to attack the sufficiency of the evidence, which means that I must explain in opening statements how it is that this cross-examination is the way that they will discover the truth, and that these inconsistencies, these differences in their stories are not technicalities, ladies and gentlemen. You won't be hearing technical reasons why you ought to let this person off. They are clues to the truth. That sounds better than inconsistencies, don't you think? Okay? What's another purpose of opening statements? To take the wind out of the prosecution's sails. Okay? You got some bad facts. Oh, I don't know about you, but usually there's a couple bad facts somewhere in the file. Okay? I had a murder case, where my client was charged with shooting a woman and leaving her in a field outside of a housing project, Outdoor Gardens, which is out in, they say it's in Chicago, but it's kind of in the middle of a field somewhere. And the body was discovered about 4 or 5 days later, where it had been decomposed partly and partially eaten by rats. Okay? Now, I thought that what Ben and his friends had done to this body really was pretty irrelevant to whether my client had done this. I mean, she was shot, and, you know, this little meal later shouldn't matter. And the pictures were bad even by my jaded standards. You know, green skin, little bite marks. I mean, you know, it's unpleasant, okay? But you all remember the number one rule of evidence, right? I move to keep these pictures out, and that motion is? Right, okay. So now I know these are coming in, right? I probably spent 15 minutes out of a 40-minute opening talking about how awful these pictures were. Ladies and gentlemen, when I saw them, I felt sick to my stomach. And I know that the last thing in the world that the prosecutor wants to do is upset you or inflame your passions by showing you these awful photographs. But he has this job, poor thing. He's got to show you that she was alive, and then later she was dead, and these pictures are terrible, and you'd probably be really upset. But don't get mad at him. You know, and I just went on and on about how terrible they were. And then during the trial, when the evidence technician is on there talking about taking the photographs and what kind of lens they use, like this is really interesting, and all that, I say, Judge, how about we just publish these to the jury now? Figuring they should throw up now, not during my closing argument. They pass them around to the jury. The jury's looking at me. They're disappointed. They've seen Chainsaw Massacre 47. This is nothing. That's another big purpose of opening statement. Let's talk a little bit about structure, okay, how you structure an opening statement. The first thing you're going to do is go back to English 101. You want to tell them what you're going to tell them, then tell them, and then tell them what you told them. I know it sounds sort of elementary, but that's what works, okay? I like to think of things in terms of paragraphs, with topic sentences, so that, you know, we're now going to talk about Mount Sinai Hospital. You know, we're going to talk about, so that people can follow what you're doing. Length of opening statements. Well, it just sort of depends. This opening statement for Yvonne Price, how long was that? 5 minutes? Maybe? Anyone know? 10? 5 or 10 minutes? Okay. Did you feel like it was long enough? Did you got the idea what was going on in the case? So you can do an opening statement in that short a period of time if the issues are simple and clean and there's not like tons of evidence. The longest opening statement that I ever did, actually my partner did, was in an insanity case where my client was upset about his divorce, and so his way of expressing that displeasure was to shoot the divorce judge and his wife's attorney in open court in front of 27 eyewitnesses. Reasonable doubt was not the defense. And that particular opening statement lasted 1 hour and 20 minutes. Okay? So I think it varies enormously. You want to try to have some symmetry in the opening statement. That is sort of a feeling that everything matches, that things close up, that it feels like it's all wrapped up at the end. Now, how many of you, please be honest, said, well, that's really nice, Andrea, but that's arguing the case, and I would never get away with that in my jurisdiction. Okay? Okay, well, there's a second rule of evidence. That's the one that saves our behinds. The first one is prosecution needs to get it in. Second one is if it's interesting, it's coming in. Okay? Interesting does shut up everybody for a while. Okay? The other thing is you may have noticed whenever I got near an adjective, a certain phrase would pop up. What would that be? The evidence will show. That's right. Just throw that evidence will show. Let the judge go back to balancing his checkbook, which is my favorite kind of judge. You know, just leave me alone. Read the newspapers, the Inquirer, whatever it is that turns him on. Leave me alone. Don't bother me. Let me try my case. Okay? Do you have judges who make calls for you? I just would assume they slept through the whole thing. That's about as much use as they are generally to me. Okay? You want to tell a story in your opening statement. You want to paint a picture, and you want to make it live. Let me give you an example. Representing a guy charged with rape. It's a consent defense. He and two of his buddies meet up with these 3 young women in a Winchell's donut shop late at night. And I actually have some pretty good evidence because the guy running the donut shop saw them meet up, talk, and leave together, which is pretty good, right? They drive to one of their apartments in the housing projects in Cabrini Green, which is just near, it's near downtown. And they go up to the apartment, and that's where the girls say that they were forced, and the guys say that it was consensual. So I actually, this particular client, Joe Cologne, happened to be on bond. I just don't usually have clients on bond anymore. You know about, do you guys have clients who are on bond? I mean, not usually, right? There's presumption of innocence and there's bond. They're two different things. But he happened to be on bond, so he was taking me around to sort of show me where everything was, where they parked the car, where they walked, where the gangway was, where the elevator was, all that stuff, so I could just sort of see. So we get there, we park the car, and he's showing me where he walked, and he's just shaking his head. He goes, Miss Lyon, he says, I just can't believe that they saying that I forced her. He says, now I admit we used trickeration. Don't you like that word, trickeration? That was my defense, trickeration. I just love that defense. I don't want to change anything about it because it has life, it has meaning, it has verisimilitude, it sounds real, it's his words, it's true, okay? Use of threes, you're going to hear that a lot around here, okay? I don't know why, but people remember things in threes. We'll fight them in the air, fight them on the land, fight them on the, wherever it is, right? I don't know why. You have crazy clients, they go to the door, and when they get to the door, they got to turn around 3 times before they can walk through the door. Have you ever noticed that? Some of my crazy clients' delusions start to feel real to me, which worries me sometimes. But for some reason, things are more easily remembered in threes. In particular, for those of you who do federal work where you have to talk about inchoate offenses and substantial steps and all that sort of boring lawyer kind of language, you can use the threes as a way of defining a word. Substantial step, actually did something, actually did more than think about it. You can use the threes as a way of defining the word without sounding like, for you idiots on the jury who don't know what inchoate means. You don't want to sound patronizing towards the jury. So, for example, when Joe cajoled, pleaded, and charmed his way into Debbie's company, Michael acted out of fear, in panic, and in defense of his life. For some reason, those things just stick. It's like a refrain of a song, okay? When we're talking about theory of the case in terms of an opening statement, I really want to say one more time, I mean a developed theory. I don't mean the surface theory. You know how we all sort of develop a shorthand for cases, right? You get the rape case in the office, right? And you look at it and you say, did he know her? No. What's the defense? ID, Miss ID, right? Did he know her? Yes. What's the defense? See what I mean? And this stuff is useful for us, okay, because it helps us to think about the cases and sort them out and all the rest of this, but it makes us think about cases in a shallow way, right? Let's take the consent defense, for example, all right? What is the question you must answer for the jury to win the case? What is the question in the jury's mind? Why would a woman say she's raped if she wasn't? Does that make any damn sense? I mean, I don't know about you. I don't want to talk about my sex life on the witness stand to a court reporter and a judge. I mean, it doesn't make any sense at all, okay? Although watching TV these days, I don't know, people talk about a lot of stuff on TV I don't understand, but you need to figure out what that question is and answer that question for the jury, okay? From there, you can go to the theme and the slogan of the case. Let me give you a sort of more complex example, right? I'm representing a man named Eric Smith who's charged in a capital case, okay? One summer night, he's standing out in his yard. He lives near 87th and Racine, which has, running on 87th, there's like a bump where there's railroad tracks, okay? He lives on the corner. And he's standing out, it's a nice warm night, in August. He's standing out there doing what anybody might be doing, smoking a joint, okay? Okay, so that looked natural. Anyway, so he's smoking a joint. He sees these guys walking south on Racine towards him, a man and a woman. And he can't tell if it's kind of affectionate or not affectionate. The man's got his arm around the woman, but it's kind of around her neck. And so he's just smoking his joint looking, and they walk through a gangway towards the alley. And so since he lives on the corner and he doesn't have anything better to do, he walks in the back, and he kind of looks down the alley, and he sees the man come out, minus the woman, running. So he doesn't have anything better to do, gets a couple of his thug friends. They drive a car down into the alley because it's pitch black in there. They find a garage door halfway open. There's the woman naked, dead, with an obvious footprint right here. She looked familiar to him. She looked like a relative of a neighbor of his across the street. So he goes and knocks on the door of those neighbors, tells them what he found, and tells them to call the police. Obviously the actions of a guilty man, because the police immediately arrest him. They question him all night long. He sticks to his story. They pick him up. They let him go. They question him. He still keeps saying the same thing. They search his house, all this kind of stuff. Anyway, eventually they let him go. 6 months later, for reasons Eric never adequately explained to me, he decides he needs a 1966 rusty Cadillac, so he steals one. And it's on the hot sheets, and he's driving. And actually, he steals it New Year's Eve. This is New Year's Day. And he's driving along, and it's on the hot sheets. Cop sees him. Lights go on. They start a chase. He drives down an alley, a T alley, that ends on the street, kind of jumps the curb, runs out, gets caught, gets arrested. Somehow or other, he floats from there to the infamous Area 2 violent crimes. No one will admit taking him. No one will admit bringing him back. And when he gets back, God bless him, he tells the lockup keeper, they beat me and forced me to confess. And he has truncheon marks on his chest and his back. You know what those are, those double parallel lines when you use a nightstick or a flashlight to hit somebody, you get double parallel lines. He has some on his chest and one on his back. Okay? Now, I file a motion to suppress the statement, but as you know, all motions to suppress will be? Right. Okay, but at the motion, I get their explanation, right, for how he ended up with the marks. And actually, he had a hairline fracture on one of his ribs, okay? Here's the explanation. See, remember the car chase? Actually, the car was going 40 miles an hour down the alley. Hit a tree, and you know those old Cadillacs, they have truncheons in them. You can end up with truncheon marks all over the place. That was their explanation. Don't you love it? So then I go and do a little investigation. I go take a look at the tree, no damage to it. Go take a look at the car, no damage to it, See what I mean? Okay, so what's my legal theory? False forced confession, right? What's the theme of the case? Ladies and gentlemen of the jury, this is a case about a false and forced confession. It is a case about the police taking the easy way out by forcing the square peg of this false, forced, and coerced confession into the round hole of the immutable, unchangeable, and contradictory physical evidence. Do you see what I mean? Complicated to simple. That's what you want to try to do when you're developing it. You want to tell the jury right away why your client's not guilty. I know I'm not going to see anybody introduce themselves tomorrow, right? You can give them your card after you win, okay? That's fine. Who cares who you are? What you care about is winning the case. Don't you love it after you've lost a case when the judge says, and for the record, I would like to compliment Miss Lyon on, don't compliment me, direct it out, goddammit, okay? Don't worry about that. If you have the need to warm up, and we all do, did you notice before I began the opening statement what I did? Did you notice? I took a couple of deep breaths because I'm terrified. You guys know something. This is harder than talking to a jury, okay? Just take a couple of deep breaths and start in on why your client isn't guilty or isn't guilty of the charge or, whatever it is that your theory of the case is. Tell us why we're there. That's the moment they're paying the most attention to you. That is the moment before the clicker. Don't waste it, okay? Give them your theme. She hit no one. She's guilty only of being poor. Again and again and again. Primacy and immediacy. What you hear first, what you hear last is what you remember best. And come back to it as often as you possibly can. Okay? You need to explain the process of the trial, okay? Especially if the case is coming in piecemeal, so that the jury will understand kind of why it is that they're not going to hear everything in the order in which it occurred, if that's how it's going to happen. But please, no road maps. No jigsaw puzzles. Please, please. I can't bear it. Let the prosecutor say that. And please don't say, ladies and gentlemen of the jury, actually you shouldn't listen to a word I'm going to say because opening statement's not evidence. Actually, opening statement as far as I'm concerned is evidence. It's really good evidence. I like it a lot better than most of the real evidence, and I do not want to tell the jury that, okay? And you want to explain discovery and investigation. And why do you want to explain that? I will tell you, because this is how I've learned most of what I've learned, by getting my ass kicked, okay? Tried an identification case. And if I say so myself, did a brilliant job. Got all kinds of admissions of inability to see things and things in the way and, vague descriptions. Steve Wrench would have been proud, did a great job, did a stirring closing argument, and the jury convicted. Can you believe it? They convicted. I couldn't stand it. I knew I'd won that case. I was very upset, and I went and talked to the jury about it afterwards. I mean, I try to talk to the juries afterwards, even when it's painful. Sometimes I'm too mad, and I don't want to get an assault charge, so I won't do it. But most of the time, you do learn things from them. And I said to them, I don't understand. And they said, we were going with you, Miss Lyon. We saw that there was lots of reasonable doubt, but you knew so much about the case, we figured he must have done it and told you. Tell them about discovery and investigation, will you please? Okay? Thank you very much. Please, no, witness A will say this, and witness B will say that. That's so boring, And it's dangerous, because sometimes the witnesses don't say that, or perhaps you can have the experience of my friend and partner, Mike Morrissey, who had a silly defense. Perhaps some of you have had silly defenses. Your client's insisting on saying his silly story, in spite of all advice to the contrary. So he explains it's an opening statement, and that his client's going to testify, and when time comes for his client to testify, the client says, fuck you, Morrissey, I'm not going up there. This is not a good moment to find that out, so be careful about how you promise. Be honest. Don't promise what you're not sure of delivering, okay? And you should hold back some of the details. You want to paint a full picture, but with a broad brush. A full picture, but with a broad brush. You want to leave some of the details, something for people to look forward to. Like, for example, and ladies and gentlemen, wait till you hear what Roger Moss does for a living. Don't tell them what it is. Give them, something to look forward to, like the teasers you see on news programs. If your defense is they don't have it, reasonable doubt, say so in a positive way. Don't defend the case, because you know how people hear it. If they can't prove him guilty beyond a reasonable doubt, sounds like he did it, but they can't prove it, okay? I am not suggesting taking on the burden of proving him innocent, okay? I'm just suggesting that you tell the jury that he might be, that you operate and appeal to that fear, the fear of sending an innocent man to jail or to death row. You want to paint a picture. Who is everybody? Like the way actors do. Places, person, time, things, what happened, what things looked like, smelled like, okay? Let me give you some examples of some opening lines, okay, things that you might want to say. For example, Ruben Frias identification case. On a dark November night, for some reason a lot of my crimes happen in November, I don't know why, okay. On a dark November night on West 18th Street, Miguel Herreria made the ghastly error of double parking his car. He was late to see his mother, and so he went in to tell his mom he was there and go move his car. And when he came out, two men ran out of an alley, each of them armed, and they shot him before her horrified eyes 13 times. They both turned, and they ran. And they are still running because, ladies and gentlemen, Ruben Frias wasn't one of them. Okay? It's important to remember primacy, immediacy. We talked about the false and coerced confession, insanity. Ladies and gentlemen, my client who was upset about the divorce, I guess you guessed that insanity was a defense. He actually wasn't sort of talking to us by the time we tried the case because we were also part of the conspiracy. He wasn't entirely wrong. A conspiracy was to just shut him up. I mean, he just would talk all the time. He was a police officer who had been injured and had something called Brown-Séquard syndrome, which means like half your body feels numb and half your body feels like it's on fire, which sounds interesting, but not all the time. And, he was a little odd. In fact, we had a jury fitness hearing with him where he said one of the things I've always wanted to say. He would talk through the whole thing. He was fit. He was fine. We were nuts, as far as he was concerned. So he and the prosecution were on the same side in this. The prosecutor was arguing during rebuttal, and Hutchie, sort of pushes himself up from the wheelchair and says, "Objection, Your Honor. They got a strong enough case without lying about it." I was allowed to say that. So anyway, okay, insanity defense. Ladies and gentlemen of the jury, you may think that you are about to look into the mind of a criminal. But you're not. You're about to look into the mind of a man marred by injury, scarred by mental illness, and warped by circumstances beyond his control. Okay? Self-defense. The morning that Michael Carter woke up and the morning that James Dixon died was an ordinary morning. Michael got up, got dressed, and went to work in a little corner grocery store in what really resembles a demilitarized zone in our city. He didn't know that Dixon was going to come into the store. He didn't know that Dixon was going to assault him on the sidewalk. And he didn't know that he would have to grab something and stab him to save his own life. But that, ladies and gentlemen, is what happened. A good opening tells a story. And what are the elements of a good story? Well, you got to have some content. Content helps, okay? You can sort of tell how much trouble I'm in if I'm in the Magna Carta at closing, okay? Structure, use of threes, children's stories help you to tell it. I kind of like to think of it as setting the scene, sort of like the credits section of the movie. Do, 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 do. Is this going to be a comedy? No. Something with jaws is going to eat something that's going to scream. I mean, okay? Sort of think, actually, I've always sort of wanted to have music during trials. Wouldn't you like that? Especially closing art. Wouldn't you like to have, like, the violins swell as you stand up, the lights dim on everyone but you? So far, I haven't been able to convince anyone of that, but I would like that a lot, okay? And you want to set the scene, for example, the interrogation room, right? Ladies and gentlemen, when you go to the police station at Area 2, if you look, there's a regular police station on the floor, and you go behind the desk, and there's some set of metal stairs that lead you up to the detective section. When you walk up the stairs, there's an echo. And when you come to the top of the room there's like a big sort of general area with desks, pool of desks and phones and seats, and ringing the room are sets of interrogation rooms. And when you go to one of the interrogation rooms, there's no window on the door, and you open the door, you walk into a room, and it's about 8 by 10. The walls are made of cinder block, and they're painted this sort of not particularly pleasant shade of green. Now, why would you do this? 2 reasons. One is you get a picture of what it looks like now, right? What's the second reason for doing it? Because you told the jury you went there. This case mattered enough to me that I got off my behind and went to the scene. I walked up the 14 flights of stairs at Stateway Garden because if the cops aren't taking the elevator, neither am I, okay? And I saw what the screen looked like against which the crime occurred. Because I can describe it with that air of having been there. And so you are doing 2 things. One is you are setting the scene of the opening statement, and you are saying to the jury, I went there. I didn't send somebody. I went. Okay? You want to try to set the mood. Okay? The mood of fear in the demilitarized zone on 7th Avenue. You want to introduce the characters. Ladies and gentlemen, I would like you to meet Frances Roberts. And I'd like you to look at her face. Because the defense and what this case is about is written right here. See that mark right there? That's where he broke a beer bottle and slashed her neck. And the one that's right above her right eyebrow, that's where he put a cigar out on her face. You want to introduce who the people are, and you want to show who they are, not just say it, not just words. You want to have some drama in your opening, but you got to leave yourself someplace to go. If you're at the top of your emotional peak in opening, what are you going to do, screech through closing? I mean, you got to give yourself someplace to go. You want to have sort of a quiet persuasion. Yes, I know, that was quiet for me, okay? You want to think about length, and you want to be willing to use silence, particularly the silence at the moment of beginning it. After all, what is a lawsuit all about anyway? Perspective, right? It's how you see it. How many of you have ever driven a car in a central downtown area of a big city in rush hour? Huh? Now, let me ask you a question. What is wrong with pedestrians? Huh? They get into the crosswalk, and they decide they want to have a little talk about Aunt Millie, right? You're trying to make a right-hand turn. You're sitting there for 4 stoplights while they talk. You can't move. Now, how many of you have ever tried to walk in a downtown area in rush hour? What, the taxis, they aim for your legs? Everything is a matter of perspective, of how you see it. And that's what you're trying to do when you're making an opening statement. You are trying to change the perspective of the jury so that they see the case in a different way. You want to paint a picture of the case and let it come out of your persuaded self so that you can give the jury permission to feel what they need to feel to vote your way. Let me say it again. You want to give the jury permission to feel what they need to feel to vote your way. It is not the facts that count. It's what people feel about the facts that count. If you have any doubt about it, look at the extraordinary people we keep electing. Okay? That's what you're trying to do. If 80% of the case is over by the end of opening statements, you cannot afford to give up this opportunity. When I began this lecture, and I know it's late and I know everyone's tired, I told you that there were two reasons why I started with an opening statement. One, I wanted you to have this sense of what it feels like to hear about the case for the first time and how much power that has and how much attention you pay to it. But the other one was I wanted to tell you, I know it's corny, but I wanted to tell you a story with a happy ending. You know, you ever feel like there just aren't very many happy endings in what we do, and you have that why do I do this stuff, and everybody hates you till they need you, and you have that why do I do this stuff, and everybody hates you till they need you, and you know what I mean? And you want to feel alone, like go to a cocktail party and tell somebody what you do for a living. You know? This is a hard time to be a criminal defense lawyer. It's a hard time to feel good about it. It's a hard time to feel like there's any chance. I mean, reading Supreme Court opinions is painful. It's just painful. You know? So I thought I would tell you this case because I won it. And because it had a really happy ending. See, about maybe 2 years or so after the case was over, Yvonne came to see me, to tell me that they'd had another little girl, and they named her Andrea. Thank you.